Are you considering a purchase of commercial property in Queensland? If so, you should be aware that the property is likely to be a workplace for the purposes of the work, health and safety legislation, and that if you become the owner, you will be responsible for identifying the existence of asbestos on the property. I'm John Gallagher from Argon Law, and I'd like to tell you some important things about asbestos management in Queensland. The first thing to know is that anyone with management or control of a workplace must ensure that any asbestos in the workplace is identified, and where it exists, 2 documents must be created and kept up to date. These are an asbestos register, which identifies all offending material, and an asbestos management plan, which describes how the asbestos is to be managed. These obligations apply to all owners of commercial property, even if they have leased the property to a tenant, albeit that a parallel obligation also applies to the tenant. These obligations don't apply if the building concerned was constructed after 31 December 2003, but only if no asbestos is likely to be present for some other reason. Most standard contracts for the sale of commercial property place no onus on sellers to provide a buyer with information on asbestos. So as a buyer, you should ensure that special conditions are included requiring the seller to provide you with copies of any asbestos register and management plan that may exist, and even a warranty from the seller about the presence of asbestos in the building. So if you need any help with such special conditions, or any other aspect of purchasing commercial property, please give us a call. And if you found this video useful, then be sure to subscribe and have a look at our website.